Don't see that it's recording. Oh, there it is. Okay, it says recording. Usually she makes an announcement. I'm just going to test my speaker real quick to make sure that it's going to pick up. Okay. Good evening, everyone. We are going to call the Board of Appeals meeting to order at 5:30 p.m. I don't have it on the agenda and I do apologize, but I will do the roll call. So Wendy Smith is here. We also have present Stephen Isaacson and also John Tutenhoff as the committee members. Also present is Inspector Burris and Attorney Bayer. The meeting has been properly noticed and posted according to law. And now I will turn it over to Chair Wendy Smith.
Good evening. This is a meeting of the Board of Appeals. Our agenda packet has been compiled by Toya. And the first item we have is item number 4, which is consideration of the meeting minutes dated June 11th and July 16th. Are the meeting minutes in here?
They were.
In the agenda packet.
I think they were at the very,
Are they at the end?
I remember.
Oh, I'm sorry. These are meeting minutes dated September 10th. And it looks like, is that front page? I only question because it says that we called the meeting to order at blank and there does not appear to be a date. Just to confirm that is the correct
It is.
minutes. Okay. Any commentary from board members as to proposed amendments or changes to these minutes? All right. Hearing none. These minutes are approved. Moving on to item number 4. Request for variance for zoning ordinance 535-19F sub 5 to construct a new 14 by 22 single car garage within the side yard setback area at residential property located at 4422 North Woodburn Street. All right. So how this is going to work is that first we're going to have a statement by the village, and then the representatives for the property can stand up at the podium, speak into the microphone, and provide your own statement to advise on your need for this variance. You don't have to get up now. We'll start with the village providing a statement. All right. We have Inspector Burris here. Yes, Attorney Baer.
I was just wondering, I know we have Attorney Sincata mentioned that he had another matter he needed to appear.
Oh, do we
at
need
this
to
evening, and
streamline
on-
proceedings?
I'm just wondering if one of the things we had talked about earlier is if, because there's only going to be a very, very brief procedural remand, which might probably just take about 2 minutes, if it would be possible, if the body would consider moving item 6 up, so that we could let the attorneys, we also have Attorney Joe Worth here, so we could let them go, just because that will probably only take maybe a minute.
Did the homeowners at Woodburn object to a 4 or 5 minute delay? Okay. We will jump ahead then to item number 6, which is the remand with direction from the Milwaukee County Circuit Court to supplement the record as it relates to the development at 2400 block of Capitol Avenue, right? Okay. All right. I believe we have attorneys present for the parties. Would attorneys like to make appearance in this matter?
Sure. Attorney Joe Worth on behalf of the village in the lawsuit that's pending in circuit court. And as the body is aware, the court has remanded this for supplementation of the record. And not that close, right, Toya? And it's going to be my recommendation today that the safest and I think most prudent course would be for the Board of Appeals to remand the remand to the Design Review Board to accomplish what the court laid out in its order of June 7, 2024. So it would be my suggestion that the board entertain a motion and then vote upon it to remand the matter to the Design Review Board to act on the court's order.
All right. Attorney Sincata, do you have comment or agreement with that approach?
Both. agreement and a brief comment. Yes, just to say I agree. This body is remanding, send it back to the design review board, and they'll do what the court describes. And so that's why we can just confirm that, and then we can take off if that, if you're in agreement. I have to be careful. If you're not in agreement, then I'm ready to argue. But if you are, then it's a pretty simple process. So thank you.
Okay. Before we call a motion on this matter, any comment from board members at this time as
No.
to the approach going forward? Okay. I have a proposed motion prepared. I move to remand the matter relating to the development at the 2400 block of East Capitol Drive back to the Design Review Board, where it shall reopen the record and further determine whether the development would cause substantial depreciation to the neighboring properties, as directed by the Circuit Court order dated June 6th, 2024. I believe what I'm looking at says 6th, but 6th or 7th. And then, okay, let's say dated June 7th, 2024. Filed on June 7th, 2024. Once the Design Review Board review is complete, it shall refer the matter back to the Board of Appeals. Is that in line with moving forward? That's my proposed motion, but I'm unclear about what happens after the Design Review Board reviews. Does it come back to the Board of Appeals, or do we leave it there? Mr. Sincata? Yes.
Sort of matter. It depends what they do. And it depends if, they do something that the appellant is not favorable of, we might reappeal it here, but I think it could well end there. I don't think it has to come back here. I think that would be an unnecessary step. They're the body that sort of makes the substantive decision. If we decide to appeal again, if we don't prevail, or if the applicant is involved and they appeal, that would be a new appeal to this body. That's how I think it should go. But Ms. Bear and Mr. Worth, a lot of legal talent here, so they can comment, but that's how I think it.
Mr. Worth, any comment?
I do agree with the concept that it probably depends what the DRB does. The court has essentially remanded it to the Board of Appeals. So I think ultimately the Board of Appeals has to take what the DRB gives it and decide whether to do anything with it at all. Perhaps it won't do anything at all. It'll just accept that the supplementation to the record hasn't changed its decision.
So is it incumbent on the parties to appeal to the Board of Appeals post the Design Review Board's finding?
I think what we can do, or what we will do, perhaps in conjunction with the court, is see what the DRB does and then make a decision on what the next step is. I think ultimately, because it was remanded to the Board of Appeals is the one that has been instructed to proceed appropriately. So it may well come back here just for, if nothing else, confirmation on the record.
Okay. Attorney Bayer?
Yes, I agree that what I would anticipate is the DRB will make a motion to supplement the record, and that'll be it. And then it'll come back to this body to essentially be a conduit to pass the supplemented record back up to the circuit court, which is asked for a specific evaluation and finding on one specific issue. And then I think it's back to the circuit court to make the final determination. So I think this body will have some role as a conduit to pass the supplemented record back up to the circuit court.
Yes, but do I need to order the Design Review Board to refer it back to the Board of Appeals?
No, I don't think so. Because I think it's going to come back through here procedurally either way. So I don't think it would necessarily have to be reflected in the motion.
Mr. Sincata?
We may have a different view of the proceedings that will occur at the Design Review Board, but we'll take that up then. I don't want to get into it now, but just so I made a comment on that, because I think we may have a little difference about the nature of that proceeding. But again, we can figure that out once it gets scheduled for DRB.
So do both parties agree to a motion that remands the matter to the Design Review Board, period?
Period. That would be good for me.
Okay. All right. Okay. All right. I will rephrase my motion. I move to remand the matter relating to the development at 2400 block of East Capitol Drive to the Design Review Board, where it shall reopen the record and further determine whether the development would cause substantial depreciation to the neighboring properties, as directed by the Circuit Court order filed June 7th, 2024.
Second.
Thank you. Toya, can you call that motion to a vote?
John Tutenhoff,
Aye.
Stephen Isaacson.
Aye.
Wendy Smith.
Aye.
Motion carried 3-0.
All right, thank you.
See you, gentlemen.
All right. Moving briskly along. Let me log back into my computer. Okay.
That, by the way, is quote unquote 2 minutes of lawyer
This is just a lot of
to 10.
lot of talking. Okay, returning to matter number 4 on our agenda, which is the request for a zoning ordinance relating to 4422 North Woodburn Street. Attorney Bayer, can you go over our standards of review for this request?
Certainly. So I know that the members of the Board of Review are very familiar with the standard and the process, but we, in the interest of transparency and educating those that appear before the body, we always go over this one more time. So the power to grant variances is afforded to this body by the Chapter 535 of the Village Code. And it says that the body has the power to hear and grant appeals for variances that aren't contrary to the public interest, where owing to special conditions, a literal enforcement of the municipal building code could result in or would result in practical difficulty or unnecessary hardship. And also, the spirit and the purpose of the overall building code is not essentially swallowed by the exception. In other words, the exception should not swallow the rule. So it should also finally prevent, public safety, welfare, and that type of thing. So the specific findings that have to be made for the Board of Appeals to allow a variance are exceptional circumstances and absence of detriment. And so the code actually defines for us what each of those terms mean. And exceptional circumstances is defined under 535-58 as exceptional, extraordinary, or unusual circumstances or conditions applying to the lot, the parcel, or the structure that do not apply generally to other properties in the same district. And the granting of the variance would not be of so general or recurrent nature as to suggest that the chapter should actually be amended. And then absence of detriment means that the variance will not create substantial detriment to adjacent property and will not materially impair or be contrary to the purpose and the spirit of the chapter or the public interest. Just to give a concrete example for those that are observing, a lot of times the Board of Appeals hears that given the age of Shorewood, we have a lot of lots that predate the zoning code. And so they are what we call non-conforming lots. For example, they might be smaller than otherwise called for in the lot, which sometimes creates practical difficulties in meeting those such things as setback requirements or location requirements of certain aspects of construction, just because the lot is essentially a postage stamp. So that's just one example of where the board has in the past recognized exceptional circumstances. So that is generally the standard. And any motion to grant should reference the fact that there's exceptional circumstances and absence of detriment found and been supported by the record. And I'll turn it back over unless anyone has any questions.
Questions for Attorney Bayer? Hearing none. We'll hear from the village first. Toya, can you swear in Inspector Burris?
Inspector Burris, do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Again, the property owners of 4422 North Woodburn seeking a variance to construct a new 14 by 22 single-car garage within the side yard setback area. The village received the building permit application on October 10th to raise an existing 12 by 20 detached garage and construct a new 14 by 22 detached garage. After completing a zoning review, the application was denied on the basis that the new garage is being proposed with a 2-foot side yard setback. The applicable zoning regulation is 535-19 F5 that provides us the rear and side yard setbacks are a minimum of 3 feet. The site conditions of this lot is that the minimum lot width is legal non-conforming The requirement is 40 feet. This lot is 37.5 feet wide. Minimum lot area is legal non-conforming. So the minimum area of a lot is 4,500 square feet. This is 3,975. The maximum allowable accessory structure is 397, and what's being proposed is only 308 square feet. So it meets that. It's still compliant with the green space requirement. And again, the only issue is that the side yard setback is proposed at 2 feet instead of 3. Within the packet, we have the building permit application, the denial letter, the zoning review, the Board of Appeals application, survey, and maps of the property.
Questions for Inspector Burris?
Not yet.
Just to confirm, is the side yard setback the only issue? The
Yep.
2 feet versus the 3 feet required?
Correct,
Okay.
yes.
All right, a representative from the homeowners would like to come up and make a statement.
You raise your right hand, please. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name.
Christine Hamill.
Thank you.
I go by Chrissy. Good evening, everyone. As I said, my name's Chrissy Hamill. I guess I've been designated as the representative to speak on behalf of the homeowners, my husband and myself. I believe the variance application is fairly complete as far as information, and I don't want to belabor the points contained within the packet of information. But what I will tell you is when we first moved into our home in May of 2017, we understood that at some point in time, we would have to replace our garage. It has been leaning in a northerly direction since the time that we moved in. We were hoping that this day may, be put off for several more years, but here we are. As you can see, I included a number of photographs within the packet that perhaps show the lean of the garage, show the placement of the garage in relation to the home. We are working with JD Griffiths as far as the new build. Jerry Kiefer has been very helpful in terms of what the structure will look like. And he had suggested that we apply for the variance given structurally where the garage is located. So the garage, I should take a step back. We do have a legal non-conforming lot, at least that's my understanding. Where the garage is located, it is located sort of behind where our home is located. And there is about a 13-foot gap between the southeast corner of our lot and where the garage is. And so when you pull into our driveway, and I'm sorry, I'm using my hands. I know I'm on the record, so I'm going to try and walk through this. When you pull into our driveway, in order to access the garage, if it were to be with a standard 3-foot setback from the south side of our property lot, you would have to turn an angle into the left. And it's a tight squeeze with the southeast corner of the home only being 13 feet distance from the garage. Shifting the garage a foot closer to the property line on the south side of our home helps to make it more of a direct shot from driveway into the entrance of the garage. I think that probably most succinctly covers the reason that we are seeking a variance. I'm happy to answer any questions that board members may have.
All right, thank you. I'll open this up to questioning from board members.
Are you using the garage now to store a car?
We are not able to, no.
How will you use it?
Going forward, it would be utilized to store one of our vehicles as well as some additional storage for my young attorney behind me's toys and belongings, yard supplies and things of that nature. Yes.
And just to call attention to, I think it's page 21 and 22 are the photos of the garage area where it appears that, like the homeowner stated, if the garage were moved 1 foot north, I suppose, there is a sharp angle between the brick side of the house to angle the car into the garage. In terms of the setback area, it looks like there's already a fence there. Is that correct?
There is, correct.
Okay. And there would be no impact on that fencing area at all in terms of recreation of the garage?
Correct. That is my understanding based on talks with JD Griffiths, that there would not be any impact to the fence or need to replace the fence with a build.
Okay.
Where are you, if I might ask, where are you parking your cars now?
In the driveway, right alongside the home.
But you're not able to put one in the garage
Correct.
because of the angle?
Because of the angle, yes. And candidly, I also think with the garage leaning, it's a little bit too risky to put something in, and the size of the garage. I mean, the home was built in 1924. Have no idea how old the garage structure is. I know it's not that old, but obviously vehicles have gotten bigger, and I don't even know. My vehicle might be able to squeeze in. It'd be a very tight squeeze and would be very difficult turning wise. But it is a very small structure right now.
So basically you're saying that it is unusable as a vehicle garage, present form, because of the leaning fact that it will fall down. That it's hard to get a vehicle in there anyway.
That is, yes, that is correct. And I wanted to, in the interest of full transparency, the reason that we are not parking in there is not solely because of the angle, but that certainly contributes to why I certainly don't feel comfortable putting a car in the garage.
So in your new design, which you are now appealing setback, how does that help you with putting a vehicle? But other than the fact that it'll be stronger because it's not going to fall down on the, but also does it make it easier, this design, to actually put a vehicle?
It does. And I'm always fascinated. I'm not a math person. And so I think, 12 inches, 1 foot, it's like, well, that's not that big of a deal. But when you do think about a foot shift south of the structure, it does allow for a straighter line into the garage and easier access versus trying to turn that tight corner right at the southeast side of the home. And so I do believe that the variance will render the new structure more usable to actually storing a vehicle as opposed to as it currently exists.
So the other question would be, if we don't grant variance, does this preclude you from using it the way in which putting a vehicle in some other? Are you still, because obviously you have a design, you're going to spend quite a bit of money building. Do you, outside of the fact of convenience, are you still able to use the structure in the manner of which you intended to build it, which would include the storage of a vehicle even with the type?
If I am, I don't know that I can say for certain, but do I think it could be used? Yes.
I mean, is it?
I
guess my question is, let me clarify it. I'll help you here. If you build it to comply with the code,
Mhm.
does that change the ability to use it in the way in which you had intended to use? In other words, is there anything that you're sacrificing by complying in terms of the fence or in terms of usage, other than the fact that it'll be a little easier to get the car in? Trying to understand if there is an economic change, both in cost and in usage, that would compel a change, compel a variance. What I would like. Or is it just, well, it would be nice to have another angle to get this thing in, but in real life, we'll use it. We're going to build it anyway.
I will tell you, we are going to build it regardless, variance or not, because we currently, this is
Need it.
why there's the Happy Halloween sheet over the entrance. We don't have a garage door right now. Because it's so old and it started falling apart. But that aside, we will still build the structure, and we would certainly do it within the parameters of the code if the variance isn't granted. However, I can say that if the variance is not granted, I do not foresee that we would use it for vehicle storage, but
Why?
rather,
Why? Why not?
why not?
I mean, I assume you
With-
could get a car in there. I mean, maybe.
With the size of it, you absolutely could get a car in
Yeah.
there, but just in terms of that really tight turn, trying to get around the house and into the garage, I don't feel comfortable making the drive and doing the corner. Maybe somebody else would. You might,
No, it's a good-
certainly,
it's
but
a
I
good answer.
certainly,
No, that's legit.
I certainly would not feel comfortable trying to sort of make that tight squeeze without running into the side of my house or scraping my car or something of that nature.
And I imagine in wintertime, when you really want the use of a garage, it would be even more difficult to navigate that angle.
Likely, yes. Hmm.
Okay.
Yep.
That answers my question.
Thank you.
Stephen, just as a note, can you pull your microphone a little bit closer? Yeah.
Sure.
Yeah, thank you.
Is that better?
Yes.
Okay.
All right. Any questions for our homeowners? I have a question for Toya. Have we received any neighbor opinion on this request, whether it's positive or negative?
We have not.
Okay.
I can share that. I mean, I know this is all hearsay, but we have spoken with a number of the neighbors surrounding us. Some who received their letter reached out to us and said, "Hey, is this for your garage?" And those who we have spoken to, I can't tell you I've spoken with every neighbor that received the notice, but those that we have spoken with said that they do not object and they would be in support of what we are trying to do. To the extent, I guess, they know what it means.
All right. Any further questions? Hearing none. Thank you.
Thank you very much for your time.
All right. I'll move to close the testimony portion of this matter and go into deliberation amongst board members.
I have a question though.
Yes, go ahead.
What is, I'm not sure I understood, what is the position of the inspector? What do you have a position on this?
I do not have a position other than, so short answer, no position. With respect to getting in and out of the garage, I would think that getting out of the garage and trying to navigate that turn would present a larger issue even than pulling it in.
Okay.
Opinion.
All right. Are we all in favor of entering deliberation?
Sure.
All right. Any preliminary thoughts on whether this meets our criteria for granting a variance?
Yeah, I can see this as just illustrated in the points itself that the lot is certainly non-conforming and a little smaller. It makes everything going to be a little bit tighter size of vehicles. What may have been 19 or garage.
Great year
So,
for cars. It was a
Karen-
wonderful year for cars.
Carriages have gotten a little bigger.
Model A.
All right, I tend to agree that the unique nature of this property and its position of the home in relation to the driveway and into the garage, I think would support our requirement of exceptional circumstances, requiring granting of a variance, and we have no evidence suggesting that there is any detriment imposed by granting a variance. It's fairly minimal encroachment into the side yard. We have no complaints from neighbors. It looks like it'll be a very nice garage. So I'm inclined to agree with John that a variance may be appropriate here. Would anyone like to make a motion?
I move that we grant the variance, that the board grant the variance.
All right, how about if I rephrase that a little bit more precisely? Move to grant the variance of village zoning ordinance 535-19F sub 5 to construct a new 14 by 22 single car garage within the side yard setback area at residential property located at 4422 North Woodburn Street, as meeting our criteria of exceptional circumstances relating to the lot and an absence of detriment in granting the variance. Do I have a second?
I'll second it.
All right. Toya, can you call a vote, please?
Stephen Isaacson,
Aye.
Wendy Smith,
Aye.
John Tutenhoff.
Aye.
Motion carried 3-0.
Variance is granted. Thank you. You're welcome.
Good luck.
All right, the final matter on our agenda is item number 5, which is a request for a variance of Village Codes 445-12 and 445-7 to allow a blade sign to remain in an unapproved location at commercial property 4518 North Oakland Avenue. Attorney Baird, you need to add any other information about our legal standard here?
No, thank you. This is also a request for a variance, so the same findings under 535-58 would need to be made with respect to exceptional circumstance and absence of detriment. So once again, we're looking for those, special conditions with respect to the property.
All right. Inspector Burris, do you have a statement?
Yes, thank you. So the business owner of Stonehouse Collective at 4518 North Oakland Avenue is seeking a variance from the sign code and previously approved plans submitted to the Design Review Board to permit a blade sign to remain in an unapproved location. On February 8th, 2024, the Design Review Board approved the installation of a blade sign subject to the following conditions. The blade sign shall be installed a minimum of 7 feet to the bottom of the sign from the sidewalk and to the top of the lintel as the maximum height. On May 2nd, 2024, during an occupancy inspection, it was identified that the sign was installed in a location that was not in compliance with the Design Review Board's condition. After a significant amount of email correspondence back and forth, the sign was relocated in August, but again in an area that did not meet the Design Review Board's conditions. Within our packet, we have a number of pictures of things, the original design that was approved. We have the meeting minutes from the Design Review Board meeting. And it's important to note that when the motion was made to approve the sign, the motion was made for a height of 7 feet as a minimum height from the sidewalk. The code, as it is here in 445-12, states specifically that a blade sign shall not exceed 6 square feet in size, shall not extend more than 3 feet from the face of a building, and shall have a maximum height, a minimum placement above the sidewalk of 8 feet. So in their motion, they incorrectly say granted something that isn't approved by the code. And then 4457H within the sign code essentially is what gives the Design Review Board the authority to grant signs. So after the comments from the applicant, the staff suggestion is that if the board finds that there is merit in the argument for granting a variance, that the matter be remanded back to the Design Review Board for approval by way of special exception. So the, again, because the code specifically limits the height to 8 and where it now currently sits is actually an inch below 7 feet, the Design Review Board can, by way of special exception, grant exceptions to the sign code.
Okay. So in the packet, there's a number of photos here. Can you tell us what photo is of the sign that it in its current state?
Yes. So let's see. Page 32 is the original location that was too high. And
And perhaps before we go off of page 32, what is the lintel?
yes, the lintel is the stone structure above the brick, above the window.
But not the stone structure under the balcony?
Same page. Yeah, so the lintel is the stone band above the windows.
Okay. So page 32 is its original placement, and then its current placement is,
So its current placement is far left of the door. It's an inch under 7 feet. I'm trying to see what page that picture.
51 and 52?
Yes.
Okay. And the measurement of the sign is currently 83 inches or so?
Yes.
Questions for Inspector Burris?
What is your recommendation?
So that if there is merit to the argument that the sign should be allowed in its present location, that you remand it back to the design review board for them to approve it by way of special exception.
Got it.
Is that 40 or 45, 23? 23?
Yes. So, yeah, the corrective order is because, so again, originally it was supposed to be on the corner of the building above the light. It is now left of the door in a location that the design review board never saw. So it's not only not on the same, in the same area, but it is also lower than what is allowed and even the mistaken motion that the board provided of 7 feet.
So it's the one that's the sign between the two windows that's too low. Is that the argument?
Yes.
Okay.
Or are you saying it's both A in the long, did you write the corrective order because A, it's in the wrong location, and B, it's at the wrong height?
Initially,
both of
well,
those?
this is the thing. So the corrective order was written to lower the sign so that it would have been within that lintel space and not above it. And when the sign was relocated, it got moved to an entirely different area on the building.
I mean, is the idea that the sign in the present location would be raised higher? That,
So what I'm suggesting is that should be at the bequest of the design review board.
yeah, makes sense.
This is a totally new spot right
Right.
So was the original design review board approval for a corner location? Is that what you're saying?
Yes.
Okay. And it was not placed in the corner location the first and second time? Or was it first on the corner?
The first time, yes, the first time it was placed on the corner, but again, too high.
Okay.
It was above that lintel.
Okay. But the code doesn't have a maximum height
It
for
does
blade
not.
signs.
No. So it was a condition of their approval between 7 feet and no higher than the top of the lintel.
Okay. Okay. Any further questions for Inspector Burris? Okay. Do we have a representative from the property that would like to come make a statement? If so, you can approach the podium.
Name is Michael Kelly. I'm the owner of the Cornerstone Building.
All righty. Can you raise your right hand for me, please? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes,
And can you state your name one more time? I'm sorry.
Michael Kelly.
Thank you.
All right. Mr. Kelly, what can you tell us about this request for a variance relating to this blade sign?
Seems like there've been some other mistakes that have been made. I was not involved when the sign was placed originally. I was kind of brought into it when the sign was relocated, and we were told that it was not in the right location and a little low. The part of this that I think is, why did that happen? The part of this that I think needs a little more explanation is the tenant, my tenant, Stonehouse, decided that they would like new lighting on the building. And those lights that currently shown in your picture are the lights that were originally installed back in 2009. And when they made that decision, it's expensive. And I'm not exactly sure, Justin, where in the timeline this occurred, but I then decided to repeat those same lights. It's a much larger light, much brighter light, all the way around the Cornerstone Building. So they might have done 5 or 6. I probably did 10, something like that. And we just thought it would be a nice addition to the building, and it would, really present to the street much better. And I think that's what, again, caused the original location on the corner of the building to change. The other thing is we have, a very vibrant patio there. It's shared with Scout Wine. So there's a lot of programming and things that go on there. There's a lot of, there are other lights that have been strung across. We have an arbor. It was, again, I think Stonehouse Collective's thought that the only kind of logical place or best place would be to move it in front of the building so that customers could see it better, wouldn't get lost in all of the activities that were occurring right under it. The sign company missed. I don't think this is one of those situations where if you give us an inch, we'll take a mile, because it's existing 1 inch below what was the direction before. I think there are, going to the factors that we just talked about in the prior motion, we have some of those same considerations with respect to this sign. When I built that building, we specifically set it back to kind of create our own courtyard and our own seating area in front of the building. It was a restaurant at the time, North Star Bistro. We're not really using it for seating. I think one of the reasons that there's a height requirement is, if something is hanging over the sidewalk or is low, someone can, damage it or grab it or hang from it. That's really not the situation here, because what they've also done is they invested in bought some very nice planters that are at each of these pilasters. So I think there might have been an issue at one time. I was thinking through, okay, well, why would there be a specific height requirement at 8 feet? You gotta, really reach up to get it. We're at 7, but no one can really reach this sign because of their other decorations. And if the design review board thought it was appropriate to say, that's a valid consideration, we'd like to put a condition that what you're showing us now will always have some kind of element like that, we'd be happy to do it. I think where this thing might fall a little short, and I'd like to provide maybe just a little different context, is when you talk about, well, the financial aspect of it. How expensive is it to move? We've moved it once already, and when these kind of things happen, they kind of look to me because they're a new business, a locally owned business. I can tell you that dollars count for them, and having someone to come out, if it's approved at this location, to move it up an inch or move it up foot an inch. There's a cost there. Then you have to repair the holes in the building. There, time, money. But I think the context that I would provide, and I wouldn't speak to specifics on this because I guess we're on the public record and it's private to them, but they put several $100,000 into the renovation of this space. And to bring this tenant to Shorewood, my investment was more than theirs. It had been a restaurant. So, I tried for a year, actually a little more. Justin, you were through a couple of times with some of our other prospects to get another restaurant there. We thought to balance off, but the restaurant business is just too tough right now. And so when this tenant approached me, I thought, I felt badly because we're providing an amenity to the people above, and I didn't want it to just sit vacant there. So I invested significant amount of money, tore out what was a working kitchen. I mean, if any of you have been in the store, I really think it's, I'm biased. I think it's the coolest store on the street. I really do. I think they put a lot of money into it. And I think with a motion back to the design review board, I would go there and I would make their case as well. In the grand scheme of things, it's not a great expense, but I think for a small business with a bank loan, it makes a difference for them. And I think, in the short while that they've been there, I think maybe irrelevant, but I think it's important to me. I love Shorewood. I like to see, the community survive and strive to make it a place where a lot of people will congregate, and they are really going out of their way to do that. They've done a number of events. I know that's not, one of the conditions that your attorney spoke to, but I think it goes to how much they have also invested in the community. So whichever way you guys want to go with it, we're certainly going to follow your lead, but in Justin's presentation there, it was perhaps appropriate to go back to the design review board, and I'd be happy to go back there, maybe not be as long-winded, say, part of it.
So since we have to look at what may be unique about your property that prevents you from being able to comply with the code, such as putting the blade sign on the corner at a height of 8 feet.
Right.
Is there anything you can tell us about the nature of the property itself that prevents you from doing that?
I don't think there's a physical reason you couldn't do it, because it was on the corner of that patio. I think though, it almost defeats the purpose of having the sign, because now you'll see our prior, they were synthetic, lights were about like this big. The profile of the current lights, I don't think there's a shot of those in the packet. Is there, Justin?
Of the former lights?
Of the former lights are shown as I reviewed the material. I
Yeah.
don't know that the new lights are shown.
You're talking about these?
There they are. Yeah, okay, so that light on the corner would have put that sign right next to it, just slightly above it.
These are the prior lights, or
These are the new ones.
the new one?
Yeah.
Yeah, look good.
Yeah, they were expensive.
I'll bet.
I know, but then when I believe the reason that they didn't want it on that corner is because they decided to do these new lights all the way around their premise. And then I carried them through on the rest of the building. So it's really not that large a sign. Could have been quite a bit bigger, but I think it sits kind of nicely there as you walk into the store. It's a good location.
So are you saying the light fixtures on the corner impede the visibility of the sign? Is that what you're trying to say?
I would think so, yeah. Or I should say, yes. And I don't know, Justin, if you have a picture of the old light, but the old light didn't cast very much light at all. And they're dated. Were dated. That's why I decided these are very bright lights and I couldn't really see it. Being between lights, I think, because the sign itself is not lit, is much easier to see.
Would you, well, Justin, go ahead.
And I, again, just wanted to clarify that the code does not require that the blade sign be on the corner. That is just where it was, say, presented through the original design.
Okay.
So the design review board could have approved it, say, anywhere on the face of the building. Again, with the height having been an issue initially is what got us here. But yes, again, that's why if it goes back to them, by way of special exception with respect to the height alone, it may be approved in its present location.
So what's issue here isn't the location except for the height.
Well, again, look, that's where it was shown when they originally approved it. And again, there's a number of elements that have changed since that original approval and original installation.
But the code does not require a blade sign to be on the corner,
Does not, no.
but it does require it to be 8 feet above.
Yes.
Okay. All right. And for the property owner, your request here is to keep it in its current location at its current height.
Yes.
Okay. Any further questions for the
Yeah,
property owner?
I'm just kind of confused here a little bit. If your recommendation is to leave it as
Yes.
is the alternative to raise it?
And as we heard from Justin, I think we would probably, as part of raising it, have to also say it's in this location. So it might be a two-part issue before the design review board.
Yes.
Is that right, Justin?
Yes.
No. See, when it was on the corner, it was well above, not a great, or a light that didn't cast a lot of light. And it kind of casted it sideways. These lights, because there's glass on all sides of it. Right.
So is this sign the original sign that was corner?
That one, I believe that's the case, isn't it, Justin?
Yes,
That
the
they
same
moved
sign that
this
was
sign?
just moved,
Yeah.
yes.
They just moved it over and put it there.
Yeah.
So the alternative might be to raise the sign a little higher?
Yeah. We'd rather not. We could, but I think the thing that's throwing this off a little, wherever there are pilaster building, there are now lights. So that's the north end. Over here at the corner, there is another one, large passing. And sign.
So are you okay with it going back to the design review board or?
Sure. Because I think we'd want to explain it to them. That is an issue about being now in putting it in ordinance. We would say, nice location, see it, and then people from tampering with that
Flowers.
flower up already. There would always be. They put that condition on it.
So the only thing that I mean, personally, that I see is it possibly could be raised a little.
I'm just
It doesn't
here to
cost.
implore the village to kind of take the whole picture and kind of the path that this has taken. That's why I'm here. I don't know. They're a little frustrated.
So this is the old Bonobo?
Yeah, went from North Star to Honorable. And unfortunately, he lost his chef. Closed in April, and I didn't meet them over a year later. I didn't like that space being vacant. We had people upstairs who were saying, gee, what are you gonna do? Probably talk to.
Same thing is going on down in Buttermint.
Yeah. Tough. It's really too bad because this should be a good off topic, but I
Sure.
think Shorewood is a great destination for restaurant. It's a tough go.
Hey, with the other business, commercial clients that you have in that building, do they have signs like this up?
I believe there's only one for the workroom. That's a home accessory store that's 2 doors down. I know there would be no objection from neighbors because I own the building across the street. And I know there are going to be no objections from some neighbors. I own the building to the north. That's an adjacent property. But Colectivo just has a sign with above that lintel, that's a sign band, as does Scout and the workroom.
Is there anything in the lease that's preventing them from actually putting up a sign then?
Preventing the
Any of the
this particular
other-
tenant or the other tenants.
Or
Yeah,
future
I-
tenants?
Yeah, I have the ability to prove it. Also has to be in compliance with Village of Shorewood ordinances. So I think it's your question as to whether others might be then asking
Yeah.
for this type of thing. And I can tell you that I can control that. And the village ordinance and the sign ordinance, as it was in 2009, is attached to it. So it requires Village of Shorewood.
Do you, I mean, maybe this is another simple question, but you're the owner of the building. What would you like it to go back to the design review board, or would you like something else?
Well, I'd like it to be taken care of tonight, but I don't know if procedurally proper. But, and I'd like that sign to remain in the same spot. Thank the village for accommodating. But if the process requires it to go back to the design review board, I'll
Clarifies it.
yeah, I think the tenant would static pass tonight. I say, well, step. Halt us.
Further questions for the property owner? Hearing none. Thank you. All in favor of entering into deliberation on this matter? Yeah, all right. This kind of feels neither here nor there because we don't grant a variance here. It appears that the design review board could approve this via special exception. Attorney Bayer, is that your understanding of the code?
Yeah, I mean, they certainly could. You know, and it sounds like the change in location was not to thumb the nose at the village, but it was just a natural progression of, you know, the fact that some things got moved around. And but the DRB essentially made a mistake and approved it at 7 feet in derogation of the code, which is technically true, but it's also true that they could grant a special exception to go down to 7 feet. So they didn't use those exact words, but
Do they need to make use those exact words?
In
Or is-
effect, that's kind of de facto what it actually
Yeah.
did. So really, we're talking about 1 inch, you know.
Yeah.
and-
All right, well, if we're looking for exceptional circumstances relating to the property, I mean, I know we're only talking about 1 inch here. Testimony is that there is cost and inconvenience in moving the sign 1 inch. Is that enough for us to warrant granting a variance?
As a cost factor, no. I wouldn't be able to see that at all. But there's too many moving pieces in here trying to where it started and where it's ended. That's why I would have to go with the suggestion of remanding it back to the design review. Trying to find some type of exception. As much as I wish I could clear this up tonight,
Yeah.
there's other tenants and there's other future developments. And if we have to keep taking each one of those case by case.
Any thoughts?
I think I would be inclined to grant a variance for the 1 inch. Looks nice. You're right, it would cause additional expense and some, maneuvering. If we could help out, then I would be in favor of that. I'm sympathetic to the thought that there's a lot of moving parts here, but it seems, what would reasonable people do? And I just simply would say, fine. That's me.
We're tired. We want to go home. Fine. I'm certainly tired. Yeah. I mean, I kind of it feels a little bit silly to have to go through all of this for 1 inch of sign and having to go back to the design review board and all of this. However, in maintaining the integrity of our standards, it may be easier for the design review board to say, yeah, this is perfectly fine, and we grant a special exception without us having to, cobble together some exceptional circumstances here where I don't really think that there are. So that's kind of where I'm thinking. If there's further thoughts, we can continue or we can entertain a motion.
Well, the only thing that I was thinking is that I think I'd be pretty confident of the outcome of this at the design review board.
Yeah.
But then what you're doing is you're putting them back in motion. It's their time to do something that maybe we could have done to save them from having to come in here.
Mhm.
But I understand the principle of the thing. I get it.
Yeah.
I just wonder if we could be helpful. And if we can, I would go for that. And if we can't, then we have to boot it.
All right. Well,
Yeah, I'd create a motion based on what I was trying to say before that I motion that we remand this back to the design review board for them to make a decision on the special exception allowed per 445-23.
Attorney Bayer, is there any problem with us not ruling on the variance?
Nope, I think it's perfectly within the inherent authority of the body to remand it back.
All right. I'll second that motion. Toya, can you call this to a vote?
Stephen Isaacson,
Aye.
John Tutenhoff,
Aye.
Wendy Smith.
Aye.
Motion carried 3-0.
So the effect of this is that we're not saying anything right now because we're not sure that it meets the requirements of variance. Instead, take it to the design review board and they'd be able to resolve the whole issue. All right. Yeah. Hmm. Well, it is a beautiful storefront. And we appreciate your time.
I have a question. Did Nana Sushi go out of business? I mean, there's no longer a sit down. I mean, I was driving by there yesterday that wondered if that was another casualty in the. Seemed like it was dark last night.
Mm-hmm. Yeah. Great. Well, thank you. Having gone through all of our items on the agenda, all those in favor of adjourning the meeting, say aye.
Aye.
Aye. This meeting is adjourned. Thank you.
Nana Suja, Nana